I'm Vinnie Politan. The subject of my investigation is the death of Boston police officer John O'Keefe and the murder trial for his alleged killer, Karen Read. This case may come down to forensics, but it's really about two people who at some point seemed to love each other. Here's the story. Karen Read and Boston police officer John O'Keefe shared a complex and sometimes tumultuous relationship. In the days leading up to O'Keefe's death in January of 2022, their text messages revealed escalating tensions. But on Friday, January 28th, they met up at a bar in downtown Canton, Massachusetts, and everything seemed fine. They displayed some affection, and a friend of John's who was there said everything seemed very normal. After drinking at C.F. McCarthy's and the Waterfall Bar and Grill, Karen dropped John off at a party hosted by fellow officer Brian Albert. The next morning, she found him unresponsive in the snow outside the house. Prosecutors allege that Karen Read, under the influence, struck John O'Keefe with her SUV and left the scene. The defense contends that John was injured inside the house and that Karen Read is being framed. This case has garnered significant public attention, with supporters rallying for Read's innocence and critics scrutinizing the investigation's integrity. As this retrial continues to unfold, it sheds light on the complexities of their relationship and all the events that led to John O'Keefe's death. There's a lot of evidence in this case, but there's certain pieces of evidence that are make it or break it for both sides. Some issues that if one side wins that issue, they win the case. And during the course of this hour, we're going to go through 4 very specific pieces of evidence and analyze if it's being proven. And if it's being proven, is it game over for the prosecution or game over for Karen Read and the defense? I want to begin here. This is the cross of Ian Whiffen, who was an expert who went through the cell phone data of John O'Keefe and others. And Jen McCabe, her cell phone data, her Google search for Haas long to die in the cold. So important in this case. Take a listen.
Correct. If you use any version from the last approximately year, that timestamp won't show up.
It won't show up as you sit here today.
Correct.
But that's not always been the case.
Correct.
In that second program, that second tool, Physical Analyzer, not only showed it at 2:27:40 a.m., but it showed it as a deleted state, correct?
It's a deleted record, yes.
A deleted record?
Yes.
Did you mention that yesterday in your direct testimony?
I don't believe so.
You don't believe so?
No, we changed it since then.
Exactly, you changed it since then.
Yes.
This issue, this alleged search, Haas long to die in the cold, at 2:27 in the morning, really gave birth to the Free Karen Read movement and gave birth to the entire defense case, alleging that something else is going on here. There's some conspiracy. And I heard that directly years ago when Alan Jackson and Dave Yannetti were on this program. So all of that brings me to our very first question in our investigation. If Haas Long was searched at 2:27 a.m., is Karen Read not guilty? Is it that simple? If that search was done at 2:27 a.m. by Jen McCabe, is Karen Read not guilty? All right, joining me tonight to help answer this and other questions, criminal defense attorney Bob Mata. He's also the host of Defense Diaries podcast, has been covering this case in depth. And Margaret McLean, former prosecutor and host of It's a Crime with Margaret McLean. Another great podcast. Thank you both for being here. Let me ask you, Margaret. We'll go ladies first, Bob. We're going ladies first. Margaret.
No problem.
If Haas Long is searched, if it's searched at 2:27 a.m., is that game over? Karen Read not guilty?
Yes, that would be game over for the prosecution, because if Jenna McCabe goes home and Googles "How long to die in the snow" at 2:27, that means she knows that John O'Keefe was somehow incapacitated inside that house, and it plays right into the defense theory that Karen did not hit John when she dropped him off at 34 Fairview. There was no collision. He likely went into the house, something bad happened, and Jen McCabe knew about it. That would mean the next morning, when Jen was playing dumb and she and Karen and Carrie Roberts went to look for John, that she knew all along that he was placed there the night before. So if the prosecution's expert, Ian Whiffen, convinces jurors that that Google search was in fact made at 6:23 and Jen McCabe searched in an open tab as he testified, then that would be good for the prosecution. Remember, the prosecution also called a second witness, Jessica Hyde, to back him up. Now, as you know, the defense will call Richard Green to try to show that that Google search took place at 2:27 a.m. If they're successful, then again, it is game over, but I don't think they will on this point, because Richard Green, he was a bit confused. He called Celebrite. He tried to get in touch with Ian Whiffen, and Ian Whiffen claims that he misinterpreted the data. So, and after that, the company fixed it. So I don't think that's going to happen. But if it does, game over.
Game over. All right, Bob, let me play a little bit of Whiffen here talking about when he believes the search actually took place.
You showed us a tab that was opened at 2:27:40, and it had something to do with Hockomock Sports.
Yes.
In your opinion, to a reasonable degree of scientific certainty, was that the same tab, that 2:27:40 tab open for Hockomock Sports, was that the same tab that later was used for searches or attempted searches at 6:23:51 and at 6:24 relative to how long or how's long to die in cold?
I believe it was, yes.
All right, Bob, let me ask you, I'm sure you agree that it would be game over if it was done at 2:27 a.m. Was it done at 2:27 a.m.?
It's a harder question to answer. I mean, we all have the benefit of watching the first trial, and
use all the information you can, Bob.
Question for me.
Use all the information you have. We're just concerned about the truth here.
I always do, Vinny. I always do. In terms of the first trial, I walked away from that having no idea, because I didn't find Whiffen or Green to give me the full answer. You know, I think the big problem for me has always been that we're never going to know what's in Apple's secret sauce in terms of their source code. So, you know, these companies exist for the express reason of trying to figure out exactly that. And I just don't know
Bob,
that any of them
explain that
have.
to the folks, because
The
this
biggest
is
problem for
Bob, I hate cutting you off, but that's a big point you're making here, is that we don't get witnesses from Google. We're not getting witnesses from Apple. Why not?
Because it's proprietary. They're not going to share. You know, it's how they make the big bucks. Both those companies. I mean, Apple is never going to send in somebody that's going to give up their trade secrets and their intellectual property. It's that simple. So we're left having to use companies that literally exist on this planet in order to try to figure out what's going on in those phones. And, you know, the bottom line is that I listened to Ian Whiffen. I didn't find him to be not credible. I found him to be a relatively credible witness. But did he answer the question for me? No. And probably the biggest reason for that is that there's companies that still show that search taking place, namely Axiom and Magnet, that for whatever reason, Celebrite, after the first trial, decided to remove whatever feature that was that would show those types of searches. And you know, for me, that was disturbing, you know, and it's one of those things where you're looking for a definitive answer, because as Margaret said, if the search took place at 2:37, it's done. You know, not only is it done for Karen Reed, but that's incredibly powerful circumstantial evidence that something in fact went on in that house. So that investigation needs to be picked up, in my estimation. So as far as you know, I don't think I'm going to end up getting the answer in this trial either. You know, fortunately for me, there's some other science out there that I'm sure you're going to be getting into.
Yeah, we'll get into it.
Pretty definitive in this case, and that's kind of where my head's always at.
Yeah, but this is one of those issues that wins it for the defense. But Margaret, on the flip side, if the jury believes it's at 623, that's not a win for prosecutors. That's not an automatic win. This issue is only an automatic win for the defense if they believe 227. If it's 623, there's still a lot more that the prosecution needs to prove.
Oh, there's a heck of a lot more, Vinny. Yeah, it's only a win at 227 for the defense because it creates a huge reasonable doubt as to, again, it goes to Alan Jackson's opening statement. There was no collision. There was no collision. It goes exactly to that. It's showing that there was something sinister going on in that 34 Fairview home. And Jen McCabe went home and she knew about it and she Googled Huss Long to die in the snow at 227. That shows that she's part of this big conspiracy and law enforcement cover-up. So that's a huge win for the defense. Game over. But the prosecution has so much to prove, and they have each and every element of the offenses to prove as well.
All right, Bob and Margaret are going to stick around. Coming up next, another big question. If John O'Keefe never entered the home, is Karen Reed guilty? Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was framed!
Karen Reed is accused of murdering her police officer boyfriend.
And stated repeatedly, I hit him, I hit him.
She may end up taking the stand. Her first trial ended with a hung jury. They haven't proven anything.
Will a jury finally agree on a verdict? We know who did it.
The Karen Reed murder retrial. Live coverage today on Court TV.
I noticed the big SUV parked in front of the house.
I noticed, looking out the window, I did notice the SUV in front of the mailbox, and then pulled up a little bit in front of the yard, and then stopped, and then pulled up again towards the flagpole.
A lot of people saw Karen Reed's SUV that night outside 34 Fairview, but nobody saw Karen Reed's vehicle strike John O'Keefe, and no one saw John O'Keefe on the ground. Those would be big issues, right? That would be important testimony, but it doesn't exist here because you don't have that type of eyewitness testimony. But what we're looking at this hour are single issues in this case that can win it for one side or the other. And one of them involves John O'Keefe and where he was once he got out of Karen Reed's SUV. Take a listen again. This is Ian Whiffen testifying about John O'Keefe's last cell phone movement.
Around 12:31, 56 or 57 is the start of the health event, 36 steps.
How long? How many seconds does that phone move for?
20 seconds.
12:31:56 to 12:32:16?
Correct.
So he's got the cell phone data and telling us when it stops and when he no longer moves and where that cell phone is, and he's saying it's outside of the house. Take a listen to Jen McCabe and Brian Albert testify about what didn't happen that night.
I saw a dark SUV out front.
Did you know whose SUV that was?
I believed it was Karen's.
Could you see who was in it?
No, I was expecting John and Karen to come into the house.
Did they ever make it in the house?
No, they did not.
John never came into my house that night. He would have been welcomed, and the defendant would have been welcomed with open arms had they come in, and I wish they had. I really do.
Evidence that John O'Keefe was never inside 34 Fairview. Prosecutors have put it out there. That's what they are arguing to this jury. And that brings me to the next question in our investigation. If John O'Keefe never entered the home, is Karen Reed guilty? Once again, if John O'Keefe never entered the home, is Karen Reed guilty? Is it game over for Karen Reed if this jury believes that the prosecution proved that John O'Keefe never entered the home? Let's bring in our experts to try to get some insight here. Joining us, longtime Massachusetts attorney Rick Grundy and criminal defense attorney Peter Ellikin, both locals out there. They know these juries, they know these courtrooms, they know the facts of this case. Let me ask you, Rick, if John O'Keefe never entered the home, never got past the threshold of 34 Fairview, is Karen Reed guilty?
So it certainly would bode extremely well for the prosecution. But I think, all of the questions this evening center on the big issue in this case, and that is that there is, for neither side, there is not a piece of evidence or a statement or one witness that nails it down for them, that is that foundation of the case. And secondly, there's really none of these major issues that there aren't two sides to be argued on. So if the defense doesn't wed themselves too much to their theory like they did in the first case, and as they may do when they take over the defense case, they could come up with another theory as to, they met him on the yard and they beat him up there and it happened there. But if they stick to this, it had to have happened in the house. It's a pretty mighty blow against them.
Let me ask you, Peter Ellikin, I want to play a little bit of the cross-examination of Ian Whiffen, because in his testimony about the cell phone data, he was kind of placing where the cell phone was. But there's one moment here on cross-examination that's a little interesting for the defense. Let's take a look.
Notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
And therefore, over the next few hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes.
So let me ask you, Peter, is it clear that he didn't enter the house, or what is going on here? Because this is a huge issue. No witness said that they saw, no one testified that they saw him enter the house. This cell phone data now, he's testifying to one thing. His graphic seems to show the possibility of something else. Is it clear that he never entered the house?
It's not clear either way, and of course that goes to the defense. I kind of I'm going to piggyback on what Rick just said, and that this is a case we do not have any proof positive. We don't have any knockout blow. We don't have any eyewitness. There's no smoking gun here. What we do have is two theories. Each kind of counteracts the other. The experts kind of cancel each other out. And when at the end of the day, if the jury doesn't, is that confused, then it goes to, it hasn't been proved beyond a reasonable doubt. So I agree with what Rick said on that case, on that matter. If hypothetically you had proof positive that he never entered the house, and that would be, I don't think it's a knockout. It's not game over, but it would be close to game over, because the jury, they want to, then they would ask the question, well, if not, didn't get in the house, if not her, then how did he die? Now I want to be clear, the law says you don't have to have an ulterior theory of what happened. And the defense doesn't have to come up with anything. The prosecution has to just prove the case beyond a reasonable doubt. So even if you could prove that he didn't enter the house, the prosecution would be greatly helped, but they would have to show that that she actually hit him. It wouldn't be enough, well, he didn't go in the house, she dropped him off. Obviously, she did it. The jury always wants to see an alternative theory, and I don't know what, there wouldn't be as many good theories. I mean, what happened? That he fell and tripped and hit his head? Or
no one's talking about the accident. No one is talking about him being under the influence and slipping in the snow. I'm fascinated by that. We have about a minute left here, Rick. Let me ask you. The flip side of this is, if he did enter the house, is Karen Reed not guilty?
Mm-hmm. I think it goes a long way in proving that, yeah. And again, this is because the Commonwealth has to prove something beyond a reasonable doubt. So they have to put forth a strong theory. They can't say, well, it could be this or it could be that. They wear their credibility thin there. So they've got to put out that, this happened out in the yard. He wasn't in there. If that evidence existed, they might have had a theory that he went in and came back out during the course of their argument. But as these things present, they're contested, and they're basically stones that they're fighting over. And in the eyes of the jurors, the individual jurors, before they collaborate, they're gathering these stones, and what's going to be dependent on the fortunes of their case is who builds the strongest wall out of those stones. Now, if it's tried with the defense putting the reasonable doubt out there, it's got to be the Commonwealth outdoes the defense and builds that stronger wall. If they get caught up like the first jury in picking up.
You're going real old school. You're building that wall with stones. Usually they build them with bricks these days. But we shall see. All right, Rick Grundy and Peter Elkin are going to stick around. Up next, if the tail light was not fully broken, is Karen Reed not guilty? I'm Vinnie Politan. We continue our investigation of the tragic death of Boston police officer John O'Keefe, a man who was raising his orphaned sister's children when he died. Prosecutors say his girlfriend Karen Reed murdered him. Here's the story. John O'Keefe, a respected Boston police officer, was found lifeless in the snow outside a fellow officer's home in the early morning hours of a bitter January morning in 2022. But what began as a tragic death soon spiraled into one of the most controversial and sensational cases in recent memory. John O'Keefe and Karen Reed's relationship was passionate but troubled, filled with love, tension, and growing suspicion. In the days before his death, their text messages showed emotional distance and rising conflict. Prosecutors allege that Karen Reed struck him with her SUV and left John O'Keefe to die. But Reed maintains she's being framed, pointing fingers at law enforcement and accusing them of a cover-up. Their once private love story has now become a public battleground, one where loyalty, justice, and truth now hang in the balance as the courtroom spotlight intensifies. And this hour, we're taking a look at some really big issues in the case that if one side or the other wins, it could be game over. Game over for the prosecution or game over for Karen Reed. Obviously, one thing we've been talking about since the beginning of this case is the tail light on Karen Reed's SUV. I want you to take a listen to the testimony of a Dighton police officer from the first trial describing that tail light. And I also want to hear you listen. I also want you to listen to Bill Reed, who is Karen Reed's father, talking about what he saw when he looked at the tail light. Both of these descriptions are before the SUV is in the full custody of Michael Proctor and the Massachusetts State Police. Take a listen.
I saw that there was some damage to the right rear taillight. To my best ability and recollection, that taillight was not completely damaged. It was cracked, and a piece was missing, but not completely damaged.
Broken taillight?
Yes.
Where exactly did you see it? Did you see it at your house or did you see it at Meadows?
I saw it at both places. So when we left the hospital, Karen wanted to see the children. And so my son drove us to Meadows. When I got out of the car, I saw it. And then when I had a cup of coffee and left there, we cleaned off the back, and I saw it as right here. And so I know what I saw.
So there was still red left?
Oh, absolutely. I would not have driven that car, all right, in the blizzard conditions that were present that morning, early afternoon, with anything of serious impairment. I just would not have done it.
Okay, so both sides agree the taillight was broken. It's a matter of degree. Was it fully broken or was it just partially broken? And these images you're looking at are images before the car is in the custody of the Massachusetts State Police. It's just after 5 in the morning when Karen Reed is driving out of the driveway and going to meet up with Kerry Roberts and Jennifer McCabe and search for John O'Keefe. So you look at that right tail light, that's what we're talking about. Is it fully broken? Is it just partially broken? Just a piece that was broken by Karen Reed when she backed it into John O'Keefe's car. All that brings us to the next question in our investigation. And this is one we spent a lot of time talking about, but now we're going to be very direct. If the tail light was not fully broken, is Karen Reed not guilty? Right? If there's just a piece missing and not that huge part of white on the taillight that we've seen in evidence photos, is Karen Reed not guilty? Joining us, Rick Grundy, Bob Motta, two great attorneys. All right, let's understand this. Let's try to figure this out. Bob, from your perspective, if the tail light, if this jury believes it, and if it's proven, and if the fact is that it's just partially broken, not fully broken, like in the final photographs we've seen of this SUV, is Karen Reed not guilty?
Yes, of course. Because the biggest issue is, how do you explain 40 plus pieces being strewn about 34 Fairview, if not for that? You know, I mean, that's when you get into the, you know, was this stuff planted? Because if the damage was minuscule or it was one cracked piece as opposed to the entire housing, the plastic housing being removed, as the pictures we've seen from the Sallyport, there's no way that the Commonwealth is going to be able to explain that in terms of the damage. So if it's a minor damage, that's clearly explained by the fact that she backed into John's vehicle. We all seen it. You know, you see the tire move. We know there was a big debate, if you'll remember, whether or not there was any contact made. And then when the defense pointed out, just look at the tire on the vehicle of John's vehicle, and you see it move. So you know there was contact made there. So as far as I'm concerned, if the entire taillight doesn't look like it looked in the Sallyport, then clearly she's not guilty.
All right, let me ask you, Rick. I'm going to put another picture up. This is from 8:23 a.m. Again, this is from One Meadows. This is before the state police have custody of the car. Take a look. Is the right tail light in this photo fully broken or not fully broken?
You'll never get me to tell, because I couldn't possibly, it would be a total guess looking at this. I agree with Bob in the sense that if a juror or the jury finds that it was not fully broken, and by that I assume you mean all that glass had come out, they've got 47 fingers pointing at corruption. And the Commonwealth can argue, you know what, look at everything else. And the jurors might. The jurors might just say, oh, you know, the taillight stuff doesn't add up, but the I hit him adds up, and the cell phone information adds up. So, again, I think it's a tough case to say any one piece is a home run, but, you know, that single finding by a jury would sanctify the defense argument that Proctor not only is a bad guy when he's talking about other people, but he's a corrupt investigator that was in charge of this case.
All right, Bob, let me flip it for you. I want to put that 823 photo up again. And if the jury looks at this and believes that this is consistent with the Sallyport evidence photo and it's fully broken, is it game over for Karen Reed? If they look at this and say, oh yeah, I'm looking at that right tail light and I don't see any red on the outer part of that right tail light, is Karen Reed, is it then game over and she's guilty?
If you're going to be practical about it and you look at the picture, the back of the vehicle is covered with snow. I don't know if that's snow or if that's that empty casing. You cannot.
I know you don't know, but what if
that kind of evidence?
Again, I'm cutting you off, Bob. I hate doing it, but I just want to follow up. Not what you're seeing. I'm telling you, 12 jurors look at that and say, oh my goodness, there is no red on that right tail light. If they all agree to that, is Karen Reed guilty?
No.
Well, in order for them to get there, they'd have to ignore two highly qualified guys from ARCA who are going to come in and say that that damage was not caused by a motor vehicle pedestrian impact and that John O'Keefe's injuries are not consistent with being struck by a motor vehicle. So if we lived in a world where they were able to, completely ignore those two guys and what I think is very credible evidence, I guess, you have to ignore all the other facts in order to reach that conclusion with regard to the taillight. If you're going to just live in the taillight world, it's a difficult case in a lot of different ways. But at the end of the day, the defense has zero burden to prove anything in this case. That lays all with the Commonwealth. And it's a really, really hard case for them to prove. It's just is.
Rick, I look at this, and if I believe that if all 12 agree one way or the other, they may not agree, but if they agree one way or the other that it's just partially broken, she's not guilty. If it's fully broken, she is guilty, because I can't think of any other explanation for either scenario, right? If the Massachusetts State Police take custody of the car and it's only partially broken, then they're planting evidence. If it's fully broken, all the pieces are at 34 Fairview.
Exactly, yes. Outside of any other evidence, if this is what they were sent with and they came to a unanimous decision that it was not broken as described by the police, that's a not guilty. And vice versa. Not quite as strong, I think, for the prosecution's case, but certainly on the defense side.
All right, big thank you, Rick Rundy, Bob Mata. Appreciate your valuable time. We will speak again. Still to come, if Karen Reed said, I hit him, is she guilty? Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was brave!
We know who did it.
The Karen Reed murder retrial. Live coverage today on Court TV. As Sean Diddy Combs faces a federal jury, Court TV's Kelly Craft is live from New York.
It was an emotional day in court.
With every development, the Diddy sex trafficking trial. Live updates on Court TV.
For you.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see. Or could I have done something that knocked him out?
That's one of the clips of Karen Reed from interviews with the media that's being played for the jury in her retrial. And there she's talking about, could I have clipped him? Meaning, could she have struck John O'Keefe? Questioning it. Now, during the course of this trial, like in the first trial, the prosecution has presented witnesses who said they heard Karen Reed that morning. when she pulls up to 34 Fairview, finds John O'Keefe in the snow. The emergency responders show up. Jen McCabe is with her. Take a listen to what they say they heard Karen Reed say.
When you looked up and saw that person and asked about any background, what did she say to you?
I hit him, I hit him, I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
Well, I asked another question. Once we had come to a stop, I asked if there had been any significant trauma that happened that preceded this, and she answered with a series of statements that she repeated. I hit him. I hit him. There was a woman next to us who told her to calm down, stop talking, calm down, you're hysterical. So she repeated, I hit him, and a police officer asked her, said, you what? And she repeated it again, I hit him.
Did you hear or do you remember the defendant saying anything to the first responder?
Yes.
What did she say?
She told the first responder, I hit him, I hit him, I hit him.
The testimony is very clear. And prosecutors saying this is a confession. This is direct evidence. It's not circumstantial evidence. This is direct evidence coming from the defendant herself, which brings us to the next question in our investigation. If Karen Reed said, I hit him, is she guilty? Could it be that simple? That if Karen Reed said, I hit him, is that a confession? Confessing to the crime, is she guilty? Let's bring in our guest who will help us answer this question. Former prosecutor, host of It's a Crime with Margaret McLean. Margaret McLean is with us. And Peter Ellikin, great criminal defense attorney up there in Massachusetts as well. So let me ask you, Peter, if she said, I hit him, those exact words, no variation of that, those words, I hit him, is she guilty?
No. And I'll tell you, first of all, I do have to concede that an alleged confession certainly is one of the stronger pieces of evidence of the prosecution. But here, she was hysterical. She was out of her mind. People record that she was saying, could I have hit him? Did I hit him? Do you think I hit him?
Wait.
I hit him.
Objection. Objection, Peter. I am referencing those three specific words. Those three words, not the variation of them. We'll get into that in a second. But you are saying even if the jury believes she said, I hit him, that is not necessarily guilty.
Yes, because of the buildup to it, it evolves into I hit him from all that hysteria. And then in support of that, we know that for hours during the evening, we have text messages and phone calls, and she's hysterical and out of her mind with grief or whatever. And she is saying, like, where are you? I mean, that would show that she really doesn't know that she hit him. If we've got hours of where are you? How come you're not calling me back? Are you with another woman? And I'm furious at you and et cetera. That shows the hysterical state of mind, first of all, and that she didn't know that she hit him at all. And finally, I just want to wrap this up by saying that all these people who said that they heard him, and I'll give you that example again, Jen McCabe heard her confess to a homicide, and yet she doesn't tell anybody for ages, and she goes in front of a grand jury, and she doesn't happen to mention, oh, by the way, she confessed to a homicide. And she doesn't even say it then, but now later on at the trial, then she said, no, that I heard I hit him. So that's not credible also. But I mean, the fact that she was in such a state of hysteria and these witnesses, didn't come up with it at the time when they actually heard a confession and didn't tell anybody. I don't think this is a knockout blow at all. This is not game over.
Margaret McLean, what do you think?
No. No, because it helps the prosecution. But remember, for every charge, the prosecution has to prove each and every element beyond a reasonable doubt. So let's go through it. Second-degree murder, have to prove 1, she caused his death. 2, she intended an act that she knew could cause his death. So that's dropping John off, pulling forward, backing up at a high rate of speed, 24 miles an hour, knowing he's right there, and then there's a strong likelihood that she could cause his death. So the prosecution has to prove all those elements. Now, 2, vehicular manslaughter under the influence of alcohol. There are 5 elements that have to be proved. Operation on a public way under the influence of intoxicating liquor, that's 0.08 or above. 4, that she operated the motor vehicle recklessly or wantonly, knowing that somebody could be killed and that John O'Keefe was killed. Now, 3, leaving the scene of an accident resulting in death. There are 6 elements that the prosecution has to prove. 1, operation. 2, public way. 3, she knew she hit him. 4, the collision resulted in death. 5, she failed to stop and provide her license and registration and her information. And 6, by failing to do so, she did it because she wanted to avoid arrest or prosecution. So just that I hit him alone doesn't do it on any of the charges.
You know what's interesting, Peter, in the first trial, the first jury, I spoke with one of the jurors about this issue, and he didn't believe it was a confession. He did not believe that the statements were a confession. It was kind of foggy, like what exactly did she say? What exactly did she mean? Let's take a listen to Jen McCabe here during the retrial.
She's doing a lot of screaming, a lot of repetitive, is he dead, is he dead, is he dead? You know, could I have hit him?
When the EMTs were around and they were working on the body, she was running around and saying, did I hit him, did I hit him, is he dead, is he dead?
So you get a mix from some of the witnesses, like you pointed out, Peter, that sometimes they're hearing, I hit him, and other times, did I hit him? And that seems to soften the alleged confession here.
And also, they're all talking about how absolutely out of her mind, hysterical, crazy, and she's not making sense, and she's babbling on, and they can't kind of calm her down. So whatever she said, if she said I hit him, but again, I really have to place that in context with she builds up to it, saying, did I hit him? Could I have hit him? And then I hit him. Oh, I must, you know, it's sort of like I must have hit him. And but in all that craziness, I think that really the testimony of the prosecution witnesses here really helped build up that idea that she's just babbling and saying anything at that time. And as I said, it's supported by all the text and phone calls all that night. And again, I can see why that juror said, I don't really know that that's a confession, that, you know, that babbling crazy stuff. And so, no, I don't think this knocks her out of the box.
All right. I want to thank both of you for coming on tonight. Margaret McLean, It's a Crime with Margaret McLean. Check out the podcast. And Peter Ellikin, he's got a whole bunch of books out there as well. He's a prolific writer in the world of law. Thank you both so much. Now, all the issues we talked about tonight, from my perspective, are really make it or break it issues for both sides. Issues that can make the difference between guilty and not guilty. But there's a big question here, because you're going to have 12 jurors who come into that courtroom, don't know each other. Will they be able to agree unanimously about the facts in this case, or will they once again be divided? I'm Vinnie Politan. We'll keep digging for answers as the investigation continues.